Welcome to Advocating for Dads with Jana Jones.
Hi, everybody. Welcome to Advocating for Dads with Jana Jones. I'm Matt Skye. Jana is a dedicated family law attorney with extensive experience in the Charlotte and Mint Hill areas. Her focus on family law, combined with her compassion and client commitment, helps families navigate the complexities of legal matters with care and understanding. Jana, thanks for joining us.
Hi, Matt. Thanks for having me.
So why is practicing family law and focusing on divorce cases specifically important to you?
Sure. I think divorce is kind of the closest thing to death that you can have without actually dying, right? It is the end of an era. You have to start over again. It is a huge cataclysmic shift in your life. And I like to be a part of helping people get to the other side of that. You know, I know that there's a reputation for divorce attorneys that like to ratchet it up and make it harder than it needs to be and just fight for no reason over the kitchen sink, the fork, etc. I'm not one of those attorneys. I really want to see people get to the other side and find a way to start their life anew, particularly if there are children involved, because to me, children are the most important thing. If we're going to fight about anything, it should be over the kids. But ideally, if we cannot fight so hard and traumatize these kids, that's ideal. So I want to be a part of that.
That's definitely rewarding work. How do you take couples when there's a lot of temper and emotions involved and get them to a place where they can mediate and discuss in a calm adult manner?
Sure. So I am not a mediator. I'm an attorney. And so I can only represent one party. So all I can do is talk to my client. Now, if they talk to their spouse or soon-to-be ex-spouse about the information that they've learned from me or tools that I've suggested, that's completely up to them. And hopefully that does help facilitate some less acrimonious situations. But ultimately, my job is to protect my clients' interests and to advocate for whatever it is they're telling me that they want.
So I guess it's almost kind of the carrot and stick approach, right? Like you give them an opportunity, but they understand that you're willing to fight when it's time to fight.
Absolutely. You know, information is power. And I feel like that's the most important thing that I can do as an attorney is to make sure they actually understand the law and how it works and will apply in their situation. And then ultimately, it's their decision as to whether or not they want to mediate, litigate, or let things go.
And how long does that, when say you have an initial intake, how does that initial conversation look and how do you determine which route to go?
Sure. So the first step is always a consultation. I offer a few different options for consultations depending on the complexity of the case. So I have a 30-minute, an hour, both by phone, because that tends to be the most economical and efficient way for most people to get information. And then I have a 1-hour in-person consultation in my office as well. So that's where anyone who is reaching out is going to start. And from there, they're telling me what they're wanting, where they're at, and I'm giving them as much knowledge as I can during that period of time about next steps and strategies, and especially what my strategy would be, and then the pricing to move forward.
So is do-it-yourself divorce allowed in North Carolina, or is a divorce attorney required for every case?
No, so there is no requirement to have a divorce attorney for any aspect of divorce, whether it's an uncontested divorce or it's a contested divorce dealing with issues related to equitable distribution and alimony. Same thing with custody and child support. There is no requirement to use an attorney. But I kind of tell people it's like I could probably YouTube and figure out how to change my oil, but I'd probably be driving down the street wondering if I screwed something on right or not, or my entire car was about to fall apart. So yes, you can do it, but it's not necessarily advisable. Additionally, people coming to me have jobs, they have careers, they have families, they have commitments, right? And trying to do a DIY divorce and learn the rules of evidence and the local rules and who to reach out to about certain issues can usually be a pretty high and tall order for most folks who have a whole life going on. And so it's just generally not very practical to try to do a DIY, but it can absolutely be done.
So even someone who feels maybe they have the competence or the ability to DIY it, you're saying that the time consumption in most cases would just be far beyond justification.
Yeah, and just the rules of evidence, frankly. My clients tend to be very intelligent people. It's not about intelligence. It's about knowing what you're doing, right? Whatever they do for a living, I could probably learn how to do over the course of years, but that's not something that I'm probably going to be successful at my first time around. And so it's a very similar thing. There's a reason that people have entire careers being divorce attorneys, because it really does take a lot of knowledge and experience to do this well. And so I think a lot of times when you're trying to DIY it, there's a lot of pieces missing. You just don't know what you don't know, and how what you're doing or not doing can affect your case. And so it just generally is advisable at a minimum to get a consultation. At least understand what your issues are and how complex they might be before you just jump in trying to do it on your own.
When you've seen cases where people have tried doing it on their own, what are some of the common mishaps or mistakes you've seen made?
Oftentimes they end up found in contempt for violation of various orders because they didn't know how serious something was. For instance, one common tool that we use is discovery to find information from the other side. And so that's generally the form of written discovery, where we're asking questions, calling interrogatories, requesting documents, and we're asking for requests for admission. And if the other side gets served with this paperwork, doesn't respond or doesn't properly respond, then that attorney is going to file something called a motion to compel. And they're going to ask the court to order that person to answer the discovery. And then if they still don't answer it, then that attorney is likely going to file a motion for contempt. And now you've violated a court's order. And now you're looking at fines, attorney's fees, jail time, etc. Simply because you don't know what you don't know, or you don't know how serious something is, or you're in your feelings instead of getting objective information from an attorney to understand how important it is to respond to these things.
So is hiring an attorney necessary when both parties are not contesting matters? Say that it seems smoothly moving as far as one can tell at first glance.
So I would say no. I'm not one of these attorneys that's going to tell you have to absolutely have an attorney every single time for every single case. No, some cases, if they're simple, if the parties are both same point, they're done with the marriage, they know how they want to split things up and go their separate ways, then there might not be a need for an attorney in that situation. But I always recommend a consultation, because you don't know what you don't know, and you don't know what you could be giving up. You guys may be amicable. Nobody may be trying to get over on the other person, but maybe one party has a significant amount of money in retirement and the other party has no idea that they're entitled to some of that money. You could be giving up thousands of dollars that you don't even know about. And it's okay if you're choosing to do that, right? As long as it's an informed decision. And that's the importance of getting a consultation, to be able to go through that stuff and talk to an attorney that can get an understanding of the assets and liabilities of the marriage. It can give you at least an overview of what you could expect in court, to make sure that if you're deciding to do this without attorneys, not in any type of contested matter, that you know what you're actually giving up.
What happens when one side can afford a very expensive attorney and the other side maybe doesn't have money for any attorney?
That can be a tough situation. There's no doubt about that. Generally speaking, as attorneys, we understand that can sometimes be the case. And so sometimes family members or friends are going to front those costs for their friend who can't afford the legal fees. We do allow that at my firm. I don't have a problem if someone else is going to pay your legal fees if you're unable to afford them. But attorneys do cost money. And the only really quote unquote free attorneys that you could potentially get are legal aid. And they generally do not deal with any kind of contested divorce matters. So unfortunately, if you want an attorney, you're going to want to budget for one.
Tell me more about the complexities of divorce, including custody support, and why having an attorney makes all the difference.
Yeah. So again, like I've said, sometimes having an attorney isn't necessary, but what is always necessary and advisable at minimum is a consultation, so that you can explain to the attorney what are the assets and liabilities of your marriage. You can talk about how you guys have handled finances to see if alimony should be something that should be considered. And you can talk about how custody has been going since you guys have separated, if you've already separated, or what you're hoping to have as a custody order or agreement once you guys do separate. And talk about child support, what's realistic to expect for child support based on the incomes of the parties. So those are all the big kind of ticket items that you want to go through in the consultation to get a general feel of what to expect.
When it comes to custody, that's maybe one of the most contentious areas. What are the factors that go into who has custody of children in complex cases like yours? Yeah,
so from the court's perspective, their job is to determine the best interest of the child or children. So they're not looking at what's quote unquote fair to mom or dad, or mom or dad or dad. They are looking at what is in the child's best interest. And sometimes, oftentimes, where that starts is a joint custody arrangement. But for any number of reasons, that might not be practical, right? Maybe one party is out of state or across the country, and a joint custody arrangement isn't going to work. Or maybe they're far apart, but the children are really young, so it works for a period of time. But once the child gets in school, that's just no longer going to be practical. So the court is looking to see what is best for these children, what is going to give them the most stability, which parent or party has been the one to take care of the basic needs of the child the most, who is going to doctor's appointments, who's going to PTA meetings. If there is medication that the child needs, who is the one administering that medication? Who's the most responsible party? Does somebody say, I can't take the kids to the extracurricular, because, I have to work or something like that, and the other party just figures it out. Those are the things that the court is going to be considering when they're determining the best interest of the child, and then what kind of schedule is the result of the best interest determination.
And what about those razor-thin cases where it's really not immediately obvious who can best provide?
So I'd say in those cases, generally a joint custody arrangement is going to be the best option. And that's usually what the court's going to end up doing as well. If the parties are close, say same school district, there's not a big issue with pickup and drop off from school. Both parties are active with the child's extracurriculars, take the child to doctor dental appointments more or less equally, are, paying for school supplies or school lunches or extracurriculars more or less evenly, then I think the default is probably going to be a joint custody arrangement.
Now, when we say joint custody, this implies that both parents are within a relatively similar radius. What are those limits usually? Is there one where it's just too far logistically?
Yeah, so I would say anytime you have parties that are so far apart that one party is not going to be able to get the child to school on time daily, then you're probably in a situation where a joint custody arrangement is not going to be practical. But if the parties are close enough together within the same city, or, I'm in Charlotte, North Carolina, which is very close to the border of South Carolina. So, if somebody's willing to fight that traffic on 77 and 85,
good luck.
Then, they may be able to pull off getting the kid to a CMS school, a Charlotte Mecklenburg school, I should say. But it's probably going to be a challenge. But generally speaking, if the parties are in a pretty close radius to one another where the school is not going to be affected, there's not going to be a bunch of absences or tardies or anything like that, then I don't see any reason why that wouldn't be where the court would start.
Now, what about cases where maybe one of the children or some of the children are in high school, can drive, they can transport themselves? How does that change the equation?
Yeah, so in those cases, a lot of times the judges are willing to speak to the child or children in chambers and ask them what they want. Now, that doesn't mean they're going to get exactly what they want, but the court will really give a lot of credence to that when they're making a best interest determination when children are that old. Because frankly, if they decide, I don't want to go to mom or dad's house, it's going to be hard to force a 16-year-old who can drive to go to mom or dad's house. So for practical purposes, the court is going to really consider what that child that is at a requisite age and able to speak for themselves is really wanting to do.
And at what age does the child's preference play a major factor? Is it like we're saying when they can drive, or say there's a younger kid who just is 8 or 7 and saying that they have one preference? How much does that factor in?
Yeah, so I wouldn't say there's a hard, fast rule. I've seen judges probably talk to kids as young as 12 or so. I haven't seen it happen under 12, not personally for any of my cases. I wouldn't say that it's completely unheard of. The court really has to determine the maturity of the child and will ask questions based on that child's maturity to try to get an understanding of what that child wants. And they're also looking for things like, is one parent coaching the child to say something, right? So that's going to come into play as well. But I would say 12 years old is usually going to be a pretty safe age for the court to consider talking to the child in chambers to ask what that child's preferences are.
Now, what is the fluidity of the results of custody? Are there check-ins? Is there, every several months to make sure that it's the right decision? Can custody be changed over time? How does that work?
Sure. So no, there are no check-ins. The court doesn't do any kind of independent investigation to see if parties are following the order. The court has no idea if the parties are following the order unless and until somebody files an action in court. And that action is either going to be a modification because they are trying to change the order, or a contempt because they are alleging that one of the parties has violated a provision of the order. So those are the two ways you're going to come back into court, and the court is going to make a determination about your case. Outside of that, the court has absolutely no idea if the parties are following the order. My advice to people is life happens, and there are going to be situations where the order that you have might not work, or at least certain provisions of it might not work. Maybe you had an exchange at 6 p.m. and for various reasons, it makes more sense to do it at noon. I always advise folks to just put it in writing so that if a contempt situation does come up because you guys are no longer agreeing to what you said you were going to do, you have proof to show, hey, I'm not violating the court's order. This was an agreement the two of us had. And that's going to help protect you and give you some defense against a motion for contempt. But the court generally is going to understand that life happens and people may need to make changes based on any number of things. And if that does happen, there's a little bit of wiggle room there. Generally, any order, particularly a consent order that I'm going to draft, is going to have language in it that is going to say that the parties can modify this as long as it's in writing. So text message or email ideally. The screenshots are not good evidence, but just something in writing that memorializes that, hey, we were meeting at the QT at noon on Sundays. Let's meet at the Exxon at 6 o'clock instead. And let's do that going forward.
So it doesn't have to be notarized or anything. It can be kind of an informal exchange agreed to by both parties.
Exactly, because it's not an order, right? That's an agreement between the parties. Unless and until you come back to court on a modification and you get a new order, your order will remain unchanged. It's just a matter of enforcing that order.
So when people are going through a divorce, they have a lot of choices for lawyers. What makes your firm different as people go through these types of cases? Sure.
So I think background matters. I am a child of divorce. My parents have a very interesting story. They got married very young, had my brother, then they divorced, they married other people, they got back together, they had me, and they got divorced again. So wow. I have been a part of a very interesting family dynamic personally. Additionally, I am a second wife, so my husband was married before, so I know what that process is like. So personally, I have some perspective on it. And then professionally, this is all I've done since I started practicing in 2009. So I have quite a bit of years of experience under my belt in doing this type of work. And I would say probably one of the bigger things is that I'm a flat fee attorney. That is pretty much a unicorn in family law, particularly in the area where I practice. So instead of billing an hourly rate, I charge a flat fee based on the stage of the case or the type of the case, obviously contingent on the factors and circumstances of the parties. But that is what I charge in full up front. So people have already paid my fee when I get to work. And I'm not having to come back and continuously ask for more and more money to be deposited so that I can keep working, or tell them that I'm going to unfortunately have to withdraw from their case because they haven't paid additional funds.
So, Jana, as we wrap up, we've covered a lot of ground here today. If you had one major takeaway for our viewers and listeners, what would that be?
Get a consultation. I think I've probably said this a few times in a few podcasts. Get a consultation. That is the best investment you can make in these situations. You don't know what you don't know. You may determine in that consultation, we don't need an attorney. We can handle this on our own. And that's great. And hopefully you can. It'll save you some money, right? But you need to know what the law is. And most folks can Google around, but you don't know necessarily how it's going to apply in your situation or how this county tends to look at certain things. So those are nuances that you're going to want to discuss with somebody that you can trust so you can make an informed decision about your next steps. So get that consultation.
I think it's a great point. Get that consultation, everybody. So thanks for tuning in to Advocating for Dads with Jana Jones. For more information or to schedule a consultation, visit lawofficeofjkj.com. Jana, thanks so much for your time today.
Thanks, Matt. I appreciate it.
Thanks for watching. If you like this video, don't forget to hit that like button and subscribe to our channel for more amazing videos like this one.